Hi, everyone. Welcome to GPSA Wellness Committee's first webinar of the year. We plan to make this a series, so we're going to try to do one wellness webinar per month, covering a range of different health topics that could potentially influence student health. This month's webinar topic is reproductive rights and health in a post-Dobbs versus Jackson women's health organization world. And to facilitate this webinar today is Samantha Bessler.
Hi, everyone. So I am Sam Bessler. I am on the GPSA Assembly, and I'm also a part of the Wellness Committee. So we have here. And today we have panelists who are experts from the Center for Public Health, Law and Policy at the Sandra Day O'Connor College of Law, and also ASU Counseling Services. And they'll be here to present and also answer questions within their scope. And so I just wanted to kind of give everyone as an attendee an idea of how this is going to go. And then I'll introduce our panelists individually and let them talk for themselves as well. And so what we'll do is we're going through as many questions from the Q&A feature as possible today. We're not going to be able to get to everyone, but we will be screening the questions and trying to get through as many as possible. And so please feel free to enter your questions into the Q&A feature. And also, if you have any additional questions as attendees and want to follow up on resources that are spoken about during the webinar, look out for an exit survey from us that'll come out in the coming weeks. And so we'll reach out with that information just so that we can get comments back from you and information about your needs for this and future webinars. We are also going to be recording this webinar. And so we do have a large online presence within GPSA and the student body as well. So we will be posting this. So also look out for information on that. We'll let our attendees know when that will be posted and also where it will be posted. And we'll just make sure that that information gets out to you in a timely manner as well. And just so to begin, what I will do is I'll go through and I'll introduce each of our panelists, and then I'll let them kind of go through, and I know they have some introductions and will speak a little bit about their expertise and information on this topic as well, and then we'll move forward into questions. All right, and so Erica, I'm just going to make you a co-host real quick. I saw that come through in the chat, so you should be all good to go. And so just to introduce our panelists today. And so first off, we have Erica White, and she is a research scholar with the Center for Public Health, Sandra Day O'Connor College of Law, and a staff attorney with the Network for Public Health Law Western Region Office. We also have Jen Piatt, and Jen is a research scholar with the Center for Public Health Law and Policy, and also the Deputy Director of the Network for Public Health Law's Western Region Office. And we also have Yasmin Puhuyesva, and Yasmin is the Program Coordinator Senior for ASU Counseling Services. And so I will turn it over to our panelists to kind of begin introducing themselves to you all as attendees and get started. So I guess if we want to go in order of how we started, or Jen and Erica, I know you guys are you're working in tandem, so whichever of you wants to start first.
Sure, I'm happy to jump in first. Hi, thanks so much, Sam, for that brief introduction. I'm Jen Piatt, as Sam mentioned, and I am faculty co-director of the Center for Public Health Law and Policy at ASU's College of Law, as well as Sam mentioned, the deputy director for the Western Region Office of the Network for Law. And what that means is, we take the time to offer legal technical assistance questions from a variety of different individuals, be they academics or practitioners or persons in state or local government. If they have a question that's related to public health law, we try to help them answer it. We don't provide actual legal advice. So we are not actually the attorneys or the counsel to those requesters, but we do answer questions, we provide resources, we host our webinars. And so we've been doing a variety of those kinds of things in this field before and after Dobbs was issued. We have a number of resources available on our network website if you're interested in digging into this a little bit deeper. And Erica has also developed some of those resources and joined me on a webinar. So I'll turn it over to Erica to just introduce herself more fully.
Yeah, thank you so much, Sam, for that great introduction, and for Jen for teeing us up. And my name is Erica White, and I am a research scholar at the Center for Public Health Law and Policy. As Jen said, here at ASU's College of and a staff attorney at the Network for Public Health Law. And yes, as Jen said, we have been following Dobbs since the moment it came out. We've been chronicling the legal landscape and all the different battles that have been happening across the country. So we're really excited to be joining y'all today to discuss them more thoroughly.
I'm Yasmin Puhuyesva. I am here to serve as some information for counseling services that are available to all of our students.
Thank you guys so much for your introductions. And Jen and Erica, I know you discussed that you had some slides to share. I didn't know if you, oh no, okay. All right, perfect. So we will jump into questions then. And so I know that our committee has some questions and we carefully formulated as well. So I figured we would kick off with these. These first few are for Jen and Erica specifically. So please feel free to, bounce off each other and answer in tandem as well. And so the first question that comes through is, the recent Dobbs decision effectively reversed the previous court decisions in Roe versus Wade, Parenthood versus Casey. So can you provide a brief explanation of these cases and what their impacts were on the American legal jurisprudence before the recent Dobbs decision?
Sure, Sam, thanks for that question. I'll take the lead on responding to this one. So a sort of brief summary of what happened in Roe and what happened in Casey. So Roe is a seminal Supreme Court decision issued in 1973 concerning the constitutional right to abortion. And in Roe, the Supreme Court determined that sort of within this idea of privacy and liberty that are protected by the Constitution, that there is a right to there is a constitutional right to abortion. And that line that the Supreme Court drew, that we still sort of operated with through Casey and on until Dobbs, that line was drawn at viability. So essentially, before viability occurs, which is essentially the time around when the fetus can survive on its own outside of the womb, before that point, the woman has this, or the pregnant individual has this constitutional right to make the decision for themselves, whether or not they want to have an abortion. And then once you hit that viability point, the court said the state's interest in this potential fetus grow. And now post-viability, the state can regulate and even ban abortion. And so what you see, in a lot of state laws is that they language into their state law and allow abortions up to the point of viability. But there were a lot of questions about, how far can states actually go in regulating, not necessarily banning abortions, right, but regulating them, putting specific requirements in place. And so the first real challenge that we got to Roe showed up in 1992 in Planned Parenthood versus Casey, when the court was, considering whether really or not to overturn Roe. And the court did not. The court decided to maintain Roe versus Wade and to maintain that constitutional pre-viability right to abortion. But what they also said in Casey is, a state can implement regulations for health and safety purposes, so be it, so long as those regulations do not pose an undue burden on the individual seeking an abortion, do not substantially sort of impact them, substantially prevent them from going and getting that service. Those regulations are allowed. And so what we had before Dobbs is this sort of legal environment where women and other individuals who can become pregnant had this constitutional right to get an abortion up to viability that could be limited in some ways by state regulations, so long as those regulations were not an undue burden. And of course, what we've seen in Dobbs is that both of those decisions have been wiped out.
Thank you so much. And just as a follow-up to the first question, so how does resulting from the Dobbs decision impact the immediate American legal environment? And what are the implications for reproductive rights kind of in the US at large?
Yeah, so you really cannot understate the legal impact of Dobbs. Just immediately, the constitutional right to access pre-viability abortion was completely wiped out. So this allows states to regulate abortion in ways that would be unconstitutional under Roe and Planned Parenthood, but now states can go even further and do what they want. So a lot of states had trigger laws already on the books that were just in place that they passed in the last years. Been predicting that, one day that Roe and Planned Parenthood case will be overturned, and that'll allow them to regulate this. So as soon as that happens, these laws go into effect. Other states have old laws that are decades old, way before Roe, that they want to start enforcing again. They can do that now post-Dobbs, but it really hasn't been that easy because there have been a lot of legal advocates who want to preserve reproductive rights that have jumped in to defend them and to challenge these laws from being enforced. So they're arguing that, well, we can't argue under the federal constitution that they're unconstitutional, but maybe under the state's constitution. A lot of states' constitutions, or their own due process rights that advocates are arguing that abortion laws can't be enforced against. Other states are saying that, or other advocates in other states are saying that portions of state law or they're in conflict with other federal laws, such as EMTALA, which requires hospitals with an emergency room that receive Medicare funds. They have to provide stabilizing care to patients, which sometimes that does include abortion care. So there's been just a swath of litigation across the states, just challenging these laws in different ways. It's just been, Jen and I have been doing a lot of, want to check out some of our resources on our Network for Public Health Law website that go into these more in detail. We've been tracking this litigation very closely, and it's been the Wild West really since the Dobbs decision.
And if I could just jump in really quickly, because I did see a question come through on Q&A to explain what a trigger law is. And I think Erica touched on this, but just to be very clear, a trigger law is a law that contains language like, should the US Supreme Court overturn Roe versus Wade and Planned Parenthood versus Casey, abortion will be banned in the state of X. So those laws were literally written with language that would trigger on the overturning of Roe or Casey and go into effect. And so that's what you're seeing with states that have sort of immediately banned abortion because they had these trigger laws ready to go as soon as that occurrence would happen.
Thank you guys for providing some additional clarification to those attendees who are posting that. Just a follow-up question as well, just in terms of some of the jargon for clarification. So we had a follow-up question come through. So what are some examples of substantive undue burden?
Sure. This really is going to be very specific to case law. Dozens of different cases address this, but I'll go into the actual issues that were on the court's plate in Casey in order to sort of explain what this means. So in Casey, different requirements that were set, regulations, right? One was that the person who is seeking abortion has to give informed consent, and they have to be given information about the procedure 24 hours in advance. Another one was that minors are going to need a parent's informed consent. And the third one is that a wife seeking an abortion will actually need to inform their husband and sort of get their husband's consent before they can go through with the procedure. And the court essentially said the first two are okay. The first two are not an undue burden. You can, require a person to give informed consent to a medical procedure. You can require information to be provided to that person before the procedure takes place. You can require a parent to give informed consent for their minor child. There are some get-arounds of that. For example, sometimes a judge can make that determination in the place of the parent. But the third prong really needing their husband's permission and or consent, the court said that is an undue burden. And that is not a requirement that is constitutional under Casey. So it's really very situation specific, and it involves the court level interpretations of what that burden is, and does it rise to that level of being substantial. But that's just an example of what we saw in Casey.
Thank you so much. And for clarifications, I know that having that kind of breath on some of the jargon really does add like a lot of nuance to the conversation. So, so just moving forward to our next question. And so, and this is a little bit more broad, so feel free to kind of answer this, but within your scope is why does this issue matter, specifically when considering holistic health and well-being of individuals, and speaking particularly among the students and community members at ASU?
Sure, I'll address this relatively broadly. Abortion is healthcare, right? And this decision allows states to deny healthcare to pregnant individuals who want or who need it. And there are a number of studies out there that demonstrate the impacts of getting access to abortion versus being denied access to getting abortion. Studies like the 10-year Hallmark Turnaway study, which has now been published in book form, but there are dozens and dozens of independent studies that formed the information that was then published in the book. And what indicated is that women fare at least the same, if not better, on every single measured metric when they have access to and can get abortions versus when they are denied those abortions. So the Turnaway study, the terminology here is really a study that followed individuals who were able to get abortions as compared with those who were turned away, who got there maybe a little bit too late after their state, gestational limit and could not get that abortion. And the metrics that they measured were metrics like mental health, physical health, socioeconomic status, employment, the impacts of a denial on the lives of existing children, incidents of domestic violence, among others. And on each of these metrics, the Turnaway study demonstrated that women will fare better, or at least the same, if they have access to abortion versus those who are turned away. The other point that I want to make here quickly is just considering the dimension of socioeconomic status here, which is really important. Socioeconomic status is bidirectional with health. So persons who are of lower socioeconomic status have a tendency to have worse health than people with elevated socioeconomic status because of the different environments that they grow up in, the different impacts on their lives. And when you consider the fact that a person with a lower socioeconomic status has less of an opportunity to travel out state to potentially a state that has legalized abortion and provide that care, when you consider a fact that raising a child is expensive and can therefore lower socioeconomic status even more, which can impact health even more, you can really see the impacts of this start to accumulate.
That's so true, Jen. And it's difficult to understate too, just the way that this is going to bleed out to other areas of healthcare. A lot of states want to ban abortion and completely or limit it in other ways, and doctors are afraid to act because there's no PDF document that says, okay, you have there's an exception to save the mother's life or the life of the child, but like what exactly does that mean? What situation does that apply in? Doctors aren't really sure what to do in a lot of states, and so they don't want to touch the patient at all in case they're opening themselves up to liability. So that's impacting a lot of people's health. Like this, a lot of people will die because of this. And then this also opens up access to contraception, and other forms of healthcare, and even like things like IVF, because a lot of doctors, if their patients don't have access to abortion care, they don't want to try to do IVF or help with reproductive healthcare at all, because that's a complicated healthcare procedure that patients will need access to abortion care for just in case. So it just really bleeds over to a lot of other reproductive health items.
Thank you guys so much for providing some clarification there. So to follow up, kind of the next question would be, have any substantial legislative changes been proposed, made, or legislatively adopted since the SCOTUS decision in Dobbs at the federal and also at the state level of Arizona, which we know would impact needs at this webinar mostly? And for example, is there any other legislation or plans to reverse or maintain the decision kind of on the horizon right now?
I can jump in. There has been action at the federal level. There have, and by action, I mean there have been bills that have been introduced at the federal level. No bill has been passed. So, you know, in the wake of the Dobbs decision, we've seen the House pass the Women's Reproductive Freedom Act, the Women's Health Protection Act. These bills generally attempt to confer a right on providers to provide abortions and a corresponding right on patients to receive them without burdensome limitations, not unlike what we've seen in state laws previously. So both of those bills actually did pass the House in July of 2022, but the Senate has blocked further action on both of them. Also currently introduced and potentially pending in the federal in the legislature is the Reproductive Freedom for All Act, which is a bipartisan measure that is intended to specifically codify Supreme Court decisions that it mentions. So it mentions Roe versus Wade, it mentions Planned Parenthood versus Casey. It also mentions Supreme Court decisions that codify the right to contraception, Griswold versus Connecticut and Eisenstadt versus Baird. So it goes a little bit beyond the issue of abortion as well, but it does specifically cabinet to that language that we've seen previously. It doesn't go any further than that. And because of that, I think the bill is not really likely to get that far. It doesn't go far enough. It's not progressive enough for some Democrats in Congress, and it likely will not receive substantial Republican support. So we haven't seen any federal bills attempting to codify and or attempting to sort of outlaw abortion at the federal level go through in this sort of post-Dobbs environment as of yet. We haven't seen any, I haven't seen any new legislation in Arizona as of yet. What we have seen in Arizona is a bill that was passed actually this past March 2022. And that is a bill that imposes a 15-week gestational limit. So you can get access to abortion up to 15 weeks, and past 15 weeks, you're unable to get that access. And that was passed, that was signed by Governor Ducey, but it does not actually take effect until September 2022.
And thank you so much for answering that question. I did have kind of a clarification question come through in the chat. And so this is just regarding kind of jumping back to the trigger laws, but it's just a clarification. So Arizona didn't have a trigger law, but our state neighbor of Utah did. Is that correct? Or is that?
Yeah, Arizona did not have a trigger law. So this is a good point of clarification, because the out there across the United States is varied right now. It's somewhat confusing. States had a lot of different kinds of approaches to this. So you'll hear sometimes people talk about trigger laws, which we've already discussed, you know, boom, Roe gets overturned and they come into effect, or it takes a very little, you know, Secretary of State action or Attorney General action to get them to go into effect once Roe is overturned. But you also have states that have pre-Roe bans. So bans that were did in those states that have them before Roe versus Wade was even issued. So well before 1973, you have a state law that says abortion is restricted or abortion is banned in this state. And so now there's a lot of litigation ongoing in many different states, Arizona included, to determine the impact and or the enforceability of those pre-Roe laws that were passed well before 1973, but were never repealed and are still on the books They just weren't enforced because of Roe. And so that is kind of some interesting pre-Roe actions that have sort of taken place in states. But of course, we've seen states act post-Dobbs. Indiana is an example, just passing a law that bans abortions and has not yet come into effect, but was the first state to pass such a law after Dobbs was issued.
Yeah, Jen, that's such a good point about the different layers of laws. One example would be Wisconsin. They have a pre-Roe abortion ban that's from even before the Civil War. It's an ancient law, and they want to enforce that again. But the problem is that they have this new trigger law that's been passed a few years ago, and it conflicts with that pre-Civil War law. And so the Attorney General is trying to figure out, what do we do with these two laws? They conflict. We can't enforce them both. And so there's all these legal questions. That's just one example about one state. This is happening across the country where there's a lot of uncertainty about what these laws.
Great, thank you guys. And so I'm just going to kind of move through the questions from the chat as well. And so there was kind of a follow-up question, and just let me know if this is something you guys can answer, but it asked, what recently happened during this primary election season in Kansas? If you guys know about that nuanced conversation and how that relates back to what you were just speaking on.
Yeah, Kansas is really interesting. We can speak on that. So we've been following a lot of this very closely in states, not just Arizona. And so what happened in Kansas is interesting because Kansas's Supreme Court has previously said that their state constitution protects the right to abortion. So not the federal constitution, we're not dealing with that. You know, the Supreme Court has decided that in Dobbs, but the Kansas state constitution, which the US Supreme Court does not have the authority to interpret because it is a Kansas state document interpreted by the Kansas Supreme Court. And they've found a right to abortion in their state constitution. And so what took place in Kansas this past primary season is that there was an initiative on their ballot during the primary to amend Kansas's constitution to say Kansas constitution does not confer a right to abortion. So attempting to sort of get rid of that previous Kansas Supreme Court decision and say there is no right to abortion in the Kansas constitution. That initiative effort failed. It was rejected by the Kansas public. I think about 59% rejected that measure to 41% in favor of it. So as of now, Kansas still does protect the right to abortion constitutionally because of that Supreme Court decision.
And I think it'll be interesting to see what's going to happen across the rest of the country to see if Kansas was a bellwether or a warning of what's to come, because this this provision to ban abortion in Kansas, this was hidden in an off-year election. Most people don't vote off elections, and then the people still came out in Kansas to vote against this to protect the right to abortion access. So it's going to be really interesting in these next few months to see if that continues across other states.
Thank you both. I appreciate you speaking on kind of issues that don't just impact Arizona, but like how the issues that are going on beyond that on a state-to-state basis might impact some of the students as well. So that's fantastic. And so moving on to our next question through the chat. And so I know that Jen, you spoke to this a little bit. This is just more of a kind of follow-up question. So with the 15-week limit, so are there any exceptions to getting an abortion after that 15-week limit in Arizona right now? Whether that's, maternal life-saving, medical necessity, or instances of rape or incest?
Yes, I can speak to that. And just to again, clarify that 15-week limit is not in effect right now. It comes into effect September 24th, 2022. So we're still not operating under that limit in the state of Arizona right now. But that bill, that 15-week limitation, did not include exceptions for rape, did not include exceptions for incest. What it did include is exceptions for medical emergency, but it defined medical emergency pretty narrowly. So I'll just share that definition with you all in case if you're interested, but it's defined as a condition that on the basis of the physician's good faith clinical judgment so complicates the medical condition of a pregnant woman to immediate abortion of her pregnancy to avert her death, or for which a delay will create serious risk of substantial and irreversible impairment of a major bodily function. So very, very, very limited language there about what a medical emergency may mean. And that definition alone could, of course, impact care, as physicians are unsure, whether a specific circumstance may fit within that specific narrow definition. And I think, could anticipate some litigation in the coming, weeks, months, years ahead to really determine what that actually means.
Thank you. And I think to kind of play on that as well. So this is more of an informational question, and I think kind of ties into the idea of maternal health, but also goes back to some of the data that you spoke about earlier. But this just asks if you're aware of any connection between abortion access and poor maternal health outcomes, especially for individuals of color. That's just asked within the context of considering like the high maternal mortality crisis in the US.
Yeah, absolutely. And that question is a very good question. We have a serious maternal mortality crisis in the United States, but we also have a serious crisis in terms of the disparities that present in maternal mortality. The rates for maternal mortality are 4 times higher in African-American Black populations than they are in white populations. There are also, elevated risks for maternal mortality in Alaska Native and American Indian populations. And that's maternal mortality, AKA you are carrying a fetus or a child to term and die. And that I think we can only, fairly say that a limitation on abortion impacts that, because you are placing more people in the position of carrying those pregnancies to term that are risky. There was a recent article published in, I think, Demography in maybe December of 2021 that took a look at what the impact on maternal mortality would be if there was like a full shutdown of wanted abortions across the United States. So you have to take this data with a grain of salt, because there's not a full shutdown yet, right? States like California, states like New York are still providing services and are still planning to continue. But if there had been sort of an entire shutdown of providing wanted abortions, this paper foresaw a 21% increase in maternal mortality in the next couple of years after that ban would be initiated. And I believe it was a 33% increase in Black populations. And that's not accounting for circumstances of unsafe abortions, of these so-called quote unquote back alley abortions or self-administered unsafe abortions. That's taking into account the risks of carrying a pregnancy to term versus not doing so. So I think certainly there is a concern there.
Thank you. And so kind of moving on a little bit, and I know that you spoke a little bit to this, I think, Erica, you did, about maybe some of the hesitancy towards reproductive technologies and such at the medical level because of the laws. But the question here is, how does the recent Dobbs court decision affect existing assisted reproduction technologies or techniques? So embryo storage, the use of IVF treatments and things of that nature.
Sure, I can start, but happy to, Erica, if you have any thoughts as well, after I start in, please feel free to jump in. This is a big question, and it's a really difficult question to answer, succinctly, because we are just now sort of in the immediate post-Dobbs legal period. And we're just now seeing the potential impacts, the potential legal challenges, the potential areas where litigation will arise. And this is undoubtedly an area where a lot of litigation is going to occur to sort of spell out or help us understand this issue. And so I think there are a few different questions here. One of the questions here, of course, is, are providers potentially facing risk, or are they nervous about facing risk for engaging in or with assisted reproductive technologies when you have circumstances like selective reduction, where you may have utilized multiple eggs in order to provide the best chance at achieving a pregnancy. And now that you have those multiple eggs, you engage in selective reduction. You reduce the number of pregnancy to ensure that that pregnancy is safe, to make sure that it's a safe pregnancy. And so the question, that immediately pops into potentially providers' minds is, engaging in that selective reduction, am I violating a state abortion restriction? Is the state law in the state that I'm, providing this service in so strict or so narrow, or could it be interpreted in such a way to subject me to potential liability? And I think that's a question that we're going to have to see, litigate, and different in each state that has different language and broader language or narrower language. And I think, the flip side of that question is not, am I potentially liable here, but would a state actually affirmatively try to apply an abortion ban to IVF or to assisted reproductive technologies, affirmatively stating, this is the subject of this abortion ban? And that's also an argument that we're going to need to see play out. I have a lingering question with the court's decision. And, ultimately, may be more of a political determination of whether states actually want to take that action, want to target IVF or assisted reproductive technologies, or whether they decide not to pursue and enforce those laws in that way for political reasons. So a lot still to be seen and to be determined on this front.
There's so much that we don't know. The Dobbs decision opens up a can of worms in the whole field of reproductive technology, that there's so many gray areas, there's so many unanswered questions that we just cannot know yet because it's too early. But this certainly will have a chilling effect. I think it's easy to say just on the field as a whole. And it opens up a lot of questions too, like Jen said, about when does viability start? And there may be other fields too, like when you're thinking about parental rights, like who has the right to an embryo. There's a lot legally that's probably going to pop up in the next months and years.
And so kind of moving on, kind of in a similar line to that question, but more in terms of like contraception. And so how does the recent Dobbs decision or new and pending legislation or policymaking efforts affect an individual's access to oral contraceptives or other methods of effective birth control?
Yeah, well, I think as Jen said too, or touched on, there's so many forms of contraception out there, and some of those maybe toe the line, like where certain groups may argue that those could be considered an abortion, like Plan B, the morning after pill, even though that's an abortion. A lot of people may argue that it is. And so because we no longer have this federal threshold and these protections that let states regulate these methods of contraception in ways that they want to. So I would not be surprised to see states try to limit access to Plan B and other forms of contraception. But this certainly opens the door to those arguments, as the Supreme Court has kind of hinted at in the Dobbs opinion.
Yeah, and I will piggyback off of that to say that definitions are always important in the law, but definitions are going to start to become even more impactful on individual health post-Dobbs, because we don't have Roe anymore, we don't have Casey anymore. But what we do have, which I mentioned very briefly at the beginning of our discussion today, is we still have Supreme Court case law acknowledging the constitutional right to contraception. So we still have Griswold versus Connecticut. We still have Eisenstadt versus Baird. Those decisions essentially on similar grounds as Roe was decided, grounded in kind of conceptions of privacy, determined that individuals, married and unmarried, have a constitutional right to use contraception. And the Dobbs decision, its reasoning in a future case could potentially apply to a potential overturning of Griswold and Eisenstadt. We're concerned about that because the reasoning in the Dobbs decision was very, but it hasn't done that yet. The Dobbs language expressly said this applies only to abortion and not to any other right. And so we still have Griswold and Eisenstadt protecting the right to contraception. But I think the legal battles that result now are number one, attempting to overturn Griswold and Eisenstadt on the same grounds as overturning Roe and Casey that were used in Dobbs, and two, arguments over what counts as contraception, as what counts as abortion, because one, constitutionally protected, one, not constitutionally protected. So I think the legal arguments that we can anticipate some serious legal arguments to come to spell that out, to attempt to spell that out.
Thank you so much. And so from a kind of healthcare perspective, and I think Yasmin, this question would go more to you from a resources perspective, but what are some of the current for healthcare related services offered at ASU through health services and counseling services to support students both during their educational and health pursuits, and where can students go to get more information on these services, just so that we can provide that to some of our attendees today?
Yeah, absolutely. So the center of our work here at counseling is really not to only prevent and intervene in suicide risk, but also to use knowledge and skills as clinicians to support our students' overall well-being. And so we know that these decisions and everything that's happened has been caused of anxiety and stress in a lot of our students. And so we have a few different options. The counseling services has our in-person services, in-person and telehealth. Students can make appointments for counseling through their health portal. They can come into the office or they can call, and this is a confidential and free of cost resource to our ASU students. And we also have My SSP, which is our app. So if anyone is to download My SSP and register under Arizona State University, that is 24/7, 365 access to a counselor anywhere in the world, as long as has access to service. They're able to chat or call with a counselor at any time. So those are our two completely confidential, free of cost resources. We also offer some peer support as well through support circles or community circles. We have a lot of different ones. If you're looking for a community of support rather than one-on-one support, those are offered around relationships, grad students, women of color, a lot of different options for those as well. So counseling can also help students get connected to a lot of different resources outside of ASU as well. They have access to work community resources. So if students are looking to just get connected with someone else outside of ASU as well. We also partner with a lot of different campus resources like SRVP, which is the Sexual Relationship and Violence Prevention Services, who have access to victim services, and also the Dean of Students. So if you're concerned about someone else that is not your own person, unfortunately, we can't go and make that outreach to that student, but the Dean of Students can. So reporting your concern to the Dean of Students can make sure that they are making well-being calls and well-being concerned about. All of this information can be found at our counseling services website. That's asu.edu/counseling. And that includes all of our resources for all of the things that I mentioned, as well as connected resources as well.
Thank you so much for all that information. And thank you to all of you for being here today and providing your individual expertise and perspective on some of these issues. I know I learned a ton just from listening to you guys today. And so these are really important and nuanced conversations to have. And I appreciate you being here to support our wellness committee and student health. And so I would just like to kind of ask each one of you individually just for some closing thoughts or takeaways or anything you want us to have moving forward. And then with our attendees today, please look out for upcoming emails from us from the Wellness Committee and surveys just to ask about your experience webinar and any questions or any follow-up information that you would like. And again, this will be posted, and look out for information is and when that's coming out as well. And so just for some final closing thoughts, Jen, if you want to start, you're the first Zoom cube up. So.
Sure, happy to. Again, thank you so much for having us join you today. It's been a real pleasure. And we are always very happy to share, information that we have, public health related information. So for anybody who has potential follow-up questions, please reach out to us. Please, check out the Network for Public Health Law's website. We do have a number of resources, as I said at the top of our discussion today, that do address the issues that we've talked about today, and that look at a lot of the different cases that are ongoing in courts right now, some of the different ballot initiatives that are going on in states around the country right now. So, the bottom line, I think, is that this is very complicated. In the absence of a federal constitutional right, state by state, the questions and the answers are very, very different moving forward, and they will continue to get spelled out. In litigation, in statutes, as we move forward, it's going to be a very complicated legal landscape.
Yeah, thank you so much for having us here today. This has been such a great experience. We're so glad to talk about this important topic. And as Jen said, we have some existing resources on our Network for Public Health Law's website. And if you have any other questions or want to talk about reproductive rights law or public health law in general, and ASU's really fantastic health law program, we're really happy to talk about what you could each one of us. But yeah, thank you so much for this opportunity today.
And just kind of being able to say once again that there is all of this stuff does cause a lot of stress and anxiety, and you don't have to be in the midst of crisis or breakdown to use any of the services. If you feel like you'd want a little bit of extra support to either work on some coping skills or be able to talk through a lot of these different things that are giving you anxiety or stress, feel free to use counseling services in person or the app. And then just if you ever need the additional support, we're always here for you.
Thank you so much, guys. We really appreciate you being here today and providing resources and follow-up kind of contacts for our students. And so we'll sign off for today. And I know there's a lot of conversations to be had, so maybe we have a follow-up in the future, but we were really happy to have you all here today. So thank you so much for your time. It's greatly appreciated.